Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. Also, aloha, because I'm currently in Hawaii visiting my sister and brother-in-law who just welcomed their first baby 2 weeks ago. My name is Jenna, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions of the speaker and interact with us. If you have a question, please type it into the comments section below and we will be sure to address it. Episodes are released each week following the live broadcast. So if you missed today or if you want to share this episode with somebody else, be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Sean Olson with us, who is out of both Colorado and Wyoming as far as his practice goes, and he's going to talk to us about keeping it simple. Now, I feel like the entirety of law school is taking us simple-minded folks and turning our brains and our thought processes into making things much more complicated than they need to be. I always say the law in general is just ridiculously and unnecessary complicated. We basically spend 3 years learning to make everything 10 times more difficult and complex than necessary, basically to justify our existence, right? Fancy words, strange procedures. At least in the United States, we don't have to wear powdered wigs. But in practice, at least as a trial lawyer, that level of complexity gets us in trouble. Sean practices personal injury and medical malpractice in Colorado and Wyoming. And as always, we will put his contact information in the description below so you can contact him directly with any questions you have about keeping things simple, colleges he's been to, seminars, anything like that, anything edge. So Sean, give us some tips on how to keep things simple with our very complex brains.
Well, I think you hit it right on the nail on the head, Jenna, when you said, we're taught to be more complex than we ever need to be, right? Than any human needs to be. Keeping things simple is something that people have been talking about for like 8 million years. I think the Buddhists came up with a concept, long before, we ever came into existence, certainly before trials ever became a thing. And it should be a core value of everything we do in life. Because I know, speaking from personal experience, when I keep things simple, I'm a happier person. Mm-hmm. But it's also a core value of the EDGE method, as you probably know, and really of any successful trial presentation, even if we don't call it that. Before you get into the mechanics of keeping it simple, how you do it, I think it's always important to understand, why it's important. Because that's another thing that gets lost along the way. When we get into, law school and we learn how to be complex and more complicated than we need to be, we forget these things. And, if you don't understand, the reason for the journey in the first place, you're never going to reach the destination that you want to hit. So, it's important, keeping things simple, and this might just seem obvious. It's important for a number of reasons. First and foremost, because people don't have very good attention spans. They're short attention spans these days, and the science shows that they're getting shorter all the time. And a lot of that has to do with our, the electronics in our lives, our kids, our jobs, the list goes on. And certainly our jurors have all of those same things going on in their minds when they're told that they need to leave their lives for a week or 2 or a month or whatever it is. That just because they're told to sit in that box doesn't mean they're going to stop thinking about all of those things. And as a result, their attention spans are short. And so if we have that privilege of getting someone's attention, our jurors' attention, we can't waste it. If we waste it, we're just going to lose the opportunity to prove our case, to tell our story, and get justice for our clients. And so one of the primary tools that we can employ to maximize what we get from their attention is simplicity. The job of a trial lawyer, anytime we present a trial, is to tell a story and communicate facts through our stories. I mean, that's the reason we call ourselves storytellers, right? And when we stand in front of a jury, we've got this core set of facts that we absolutely must convey to that jury so that the jury understands our case. The Edge these days calls that our hits. And those hits, they're all composed of facts. And we need the jury to not only hear those facts, we need the jury to retain those facts and understand them. Now, one way, we could convey all those facts would be just give them a grocery list style of presentation for that. But the human brain, isn't at its maximum efficiency with that style of communication, just throwing out a list of things, hoping everyone remembers and understands what the hell it is that you're trying to communicate. The science indicates that a person's short-term memory can absorb about 7 to 10 facts. And the brain will store those 7 to 10 facts in an area of the brain where the short-term memory lives, and it'll store them there for about 30 seconds. And after 30 seconds, those facts just get dumped out. If you're not doing anything with them, you literally forget them again, and they're gone forever. But when we hear stories, instead of activating just that one spot in the human brain where facts are stored, we activate half a dozen places in our brains. And our brains release chemicals like dopamine and adrenaline and make us feel the story that's being told. Think about those times where you walk out of a movie, out of Top Gun, and you're walking back out to your car and you think, holy crap, I've got to go be a Top Gun pilot. I'm hanging up the law license and I'm joining the Air Force, right? That's that dopamine rush that you get from hearing a really great story. And so when all those things are going on, you're activating those parts of the brain. Your brain is then taking the facts that you've heard, and instead of just storing them in your short-term memory, it's putting them in 5 or 6 different places. And then your brain is actually making physical connections between those facts so that your brain can hang on to it. And when we do all that, you don't forget them. You understand exactly what it is that the person was trying to convey to you. You hang on to those facts and quite possibly hang on to them forever. So a good illustration of this is the story of Little Red Riding Hood. Now, Jenna, I think you're probably a little younger than I am. But,
Oh, no.
But when's the last time anybody told you the story of Little Red Riding Hood?
I think it's been a while. Yeah, it's been a while.
Yeah, probably at least like a decade, maybe 2 decades.
Yeah.
But I'll bet you can sit here and tell me the name of every single character in that story and what those characters did.
I probably could give you the gist of it. I think you're putting me way too on the spot, but I think I could give you the gist of it. Oh God, now I'm stressed. I feel like I'm going to get a pop quiz here.
If Little Red Riding Hood is Grandma, the wolf, and the lumberjack, right?
Yep.
They all have different roles to play, and we remember those things. Even sitting, I haven't heard the story of Little Red Riding Hood in probably 20 or 30 years, but I remember it all, and there's a reason for that, because you're hearing a story, and the story is simple. It's not complex. Each character has a small role to play. They have a couple of lines, and we hang on to that because it's easy to understand. We don't get tied down in the details about the kind of trees that the forest was made up of, the Little Red Riding Hood was walking through. We don't talk about in the story about the fact that wolves are endangered species and they're entitled to certain protections. We don't talk about the average age that grandmothers live and things like that. We don't get into those things. The story is kept simple because it's made for children, right? And children have even shorter attention spans than we as adults do. So you keep it short, keep it simple. And as a result, 30 years later, I can still rattle off the 4 characters that were in it. Compare that to a story, that you've heard more recently in time, maybe an undergrad, in English or whatever, that a story that you read. One that comes to mind for me is The Scarlet Letter. I think everybody in the country probably reads that one. Name all the characters from that story. Yeah, almost impossible, right? because it's a complex story, you know, with all kinds of details. It's long, to a large degree, it's boring, you know, and so as a result, you know, we're sitting here even closer in time to hearing the story or reading the story. And you and I can't sit here and talk about those characters or what their names were or what they did, because it wasn't a simple story. It was complex. And it just doesn't have the same impact then in the long term that you get from hearing a short, simple story. You know, that's what made Little Red Riding Hood effective. It was short, it was simple, it made you feel something, and it made you remember. Here's another example of that. All right, try to do this for me, Jenna.
Okay.
I'm going to give you a set of facts, and I want you to remember each of the facts and remember them in the order that I told them to you.
All right.
All right. So stairs, monkey, iron, string, window, kite, oranges, turtle, mouth, river, rock, tree, cheese, fire, gravestone, and tornado. So when I'm giving, right, when I'm giving you that list, you know, you took the 7 to 10 of those facts that I started rattling off, and you threw those in your short-term memory, right? And that's where they're living for the time being. And now sitting here right now, because there was more than 10 that I gave you, can you remember what those were in the order that I gave them to you?
Staircase, monkey, window.
Right. The point is,
ladder, cheese.
It's tough to do it.
Yeah. Well,
right?
See, this is my concern. Like, what if a doctor gives me an Alzheimer's test and they're like, remember 3 things, and then they talk to me about something else and they're like, what are those 3 things? I don't think I could do that. So what, you know, I mean, is this just part of like, memory is so complex that we don't really understand what it means to be able to remember certain things.
Right. But here's the trick. So with this list of facts and the list of 3 facts that you'll get when you get that Alzheimer's test, let's create a story with the facts. Right. So if you do that, so if I tell you a story now, I say, look, I came home the other day. First thing I did, I went up the stairs. And when I got to the top of the stairs, I ran into a monkey of all things. And that monkey was just standing there, and in his hand was an iron. Attached to that iron was a piece of string. And the string fell off the iron and went out the window. And at the other end of that string was a kite. The weird thing about that kite, it was made of oranges. And at the bottom of that kite, there was a turtle. The turtle was just hanging on to one of those oranges with his mouth. And then he let go. And the turtle fell down into the river that was below the kite. And when he fell into the river, he hit a rock. And that rock popped up off of the river bottom and fell into a tree. And the weird thing about the tree is that the leaves were all made of cheese. And as the turtle was falling down through the cheese leaves, he caught on fire. And when he caught on fire, he kept falling down and he landed on the ground and died. Fortunately, he died right next to a gravestone. Because when a tornado then came by and swept the turtle up, the gravestone was there so that we remember that turtle forever. Right, so it's a simple story. So now we've taken those facts, put them into a story, and I'll bet you can list through all of those facts that I gave you simply because we created a story, a nonsensical story. Can you do it, Jenna? Can you list them all?
I might be able to.
Right,
Are you going to ask me to? No, but I think I probably could.
Yeah, I won't put you on the spot, but you can, right?
Yeah.
I have no doubt that you can, because your brain did all those things that we talked about. It took that simple story, took the facts that you needed to retain, stored them in 5 or 6 different places, and now they're yours, right? You could probably go out for a drink tonight and tell the story about the monkey and the kite.
Well, and the interesting thing about that is, so like when you were saying the words on their own, I tried to picture them in my mind, because I was like, okay, if I just remember the word, it won't have any meaning. So let me try to picture each thing. But then it got too crazy, and there's all these pictures flying around in my brain. But then when you told me the story, I was able to picture it and follow it. And now if I had to go back and see you walking up the steps, and there's this weird monkey up there, and he's got an iron, and there's a string attached to it, and there's a kite, and that's odd, it's made of oranges, and there's a turtle, and it's just like, it's context, I guess, versus just a bunch of scattered facts.
Right. It's all context. And that's our job as lawyers, is to take all those facts that we collect during the course of putting a case together, put them into context, put them into a story so that people, remember them and understand them and do the right thing with them. The inverse of keeping it simple is also true. If we take that same story and we start to, again, we discuss the quality of the wood that made up the stairs or the wind speed and the barometric pressure, that was moving the kite around, we're going to lose attention. And once we lose the attention, then nobody's listening. And if you're not listening, you're not going to absorb any of it, and we've lost that opportunity to have a juror's attention along the way. So, you brought this up to begin with, we know as children, as young people, even through undergrad, we know the value of simplicity. This isn't some great secret that, we're imparting as lawyers now, right? But we go to law school and it all changes. Everything changes, right? The first thing one of the first cases we read is Paul's graph. Right. And it's an interesting case. Everybody remembers that weird story. But Paul's graph is 14 pages long. Right. And that's probably one of the shortest cases that we read during our first year of law school. And that discusses just a single topic, that we have to learn as lawyers. Right. And the judges took that topic, they spread it out over 14 pages, made it complex, filled it full of detail. And that's just the beginning, and then from there, we're reading, cases that are 90, 100, 150 pages long. And we pick up on it. And as lawyers, we begin to assume that in order to be effective lawyers, simplicity has to go out the door, and that might be for a number of reasons, but that's what we start to believe. And we have to use words like heretofore, and when we start talking about stories and what a case is all about, we include every single fact that we can possibly conjure to tell a story, and we do that, for fear that the record will be incomplete. When it goes up on appeal, we got to include all that stuff. And we abandon the concept of simplicity for the concept of complex. And we do it for, primarily because of fear. Fear of not saying something we should, fear of looking stupid, and mostly for fear of losing. The last thing any of us wants to ever do is get done with a closing argument and, see the jury walk back into the jury room and then think, holy cow, I forgot to tell them X, Y, and Z. I mean, how many times does that happen? And it certainly happens to me almost every single time, I think. But it's that fear. It's that fear of not giving them everything that's going to win our case. But what's important in those circumstances, is what we do in response to that fear. And that our response to that fear is really what dictates whether we win or lose at trial. So, when it comes down to, what is simplicity with trial presentation, it's really just a matter of breaking down the complexity of our cases into its individual parts and then getting rid of all the things that don't matter. And, that's what the edge is all about. We never really talk about it in those terms, but that's what it is, and then putting that all back together so we have a comprehensive, cohesive story about what happened to our clients, what the defendants did, that's short, that's simple, and gets the job done. It's a lot. When I was putting this together and thinking about this, it's kind of like, I don't know, I may be the only person who's ever done this, but I watch YouTube videos of people doing bonsai trees. One of the most relaxed,
that sounds very calming. Yeah,
it really is.
Yeah.
But they take these tiny little bushy trees that are kind of cool unto themselves, but then they spend an hour trimming. They have these tiny scissors and they trim and take tiny branches off and little leaves, and at the end, even though you got rid of all these things that made up the tree, you end up with this cool little piece of art. and it's the essence of what that, that artist saw the tree. And that's kind of what we do, and when we're talking about simplicity and cutting a case down to its core, that's what we're doing. We're trimming and, making it the story that we want to tell based on what the jury needs to understand. Part of my background, before I became a lawyer, I worked in TV. And so I did that for about 10 years. And much of that time was spent behind the camera. And so I was cinematographer for a long time. And one of the things that I did is I worked in local news. And so when we worked in local news, every day was spent, you get in at 9 o'clock, you go out, you collect a story that you have to tell, then at 5 o'clock or 10 o'clock or whatever the case may be. The caveat there was always that story had to be simple. And to be simple, it had to be short. And most of the time we had a minute and 30 seconds to tell that, no more, right? There was never any going to a judge and saying, hey, I could use just a minute more just to get my point across. We didn't have that opportunity. We didn't have that luxury, right? Minute 30 was a hard deadline. And
that's tough.
Yeah, you weren't allowed to go over.
Mm-hmm.
And so the tough part about it was, we'd spend a whole day. Sometimes we'd spend days, plural, or weeks, collecting and gathering all this material, doing interviews, getting these cool shots and seeing things. And, we'd bring it all back and we'd have hours of material to present and only a minute and 30 seconds to do it. And so really, that's where I sort of began to understand this concept of, how do we reduce this? How do we bring this down to its core parts, to make it short, make it simple, make it interesting. And so that everybody understands what happened. And it takes a long time. It took a lot of work to get to that point, and a lot of criticism, critiquing and things like that. But, 9 times out of 10, once you get to that point, you get down to that minute 30, it's a better product than it was at 7 minutes or 10 minutes or whatever it was. And telling a story at trial is no different. We spend, weeks, months, sometimes even years in discovery and putting our cases together, getting to know our clients, finding witnesses, before and after witnesses and things like that. But we have a lot of material for our cases. And, it's appealing to want to present all of that, and show the jury everything that you've done, everything you've collected, because it's moved you so much, as you've gotten to know this case and become involved in it. When you do that, then you're talking about a 2, 3 week, 4 week long trial, for a rear ender that happened. First of all, you're never going to get permission from the judge to do it. But you're going to lose jurors along the way because jurors don't have the involvement that you have. And you need to be able to stand in front of them, present a simple story about what happened, present the simple story about how that affected your client so that they can take those facts and then render a verdict that, equals justice. The people who don't,
well, I was just going to say, is there ever, and this is my complex brain asking this question, but is there ever a situation where a jury doesn't have enough? We hear all the time from our jurors, I didn't have, proof of this. I didn't have proof of that. And maybe it's because we have a bunch of tech-minded a-holes over here in Washington, but they're like, well, I didn't see the document that proved this, or I didn't see this, or I didn't, and they want every ounce of detail. But maybe that's because we fed them too many details and it got them down the detail path and focused on the wrong thing. I don't know what happens in that situation.
Well, that's a real danger, and, that's the kind of thing that black hats thrive on, right? Mm-hmm. They thrive on making it complex, especially with, medical malpractice cases that we do out here, the way they win those cases is by making it so difficult to understand that the medicine is so complicated that you as a juror couldn't possibly understand what Dr. Smith was up against, when he was performing this procedure. Mm-hmm. And, there's so much pressure and it's so complex and so hard to understand. that everything he did was reasonable under the circumstances because he just had to use his own judgment.
Mm-hmm.
Right? That's the danger. And, if we're presenting a bunch of medical records and, records of everything, 60 photos of everything that occurred, that's the real risk. That risk that you're pointing out is that we end up giving them too much. And, and then they start asking questions of themselves and looking deeper beyond the issues that any lawyer in the case has ever thought to bring up.
Yeah.
And when that happens, they think, well, they didn't prove their case.
Right. Well, yeah, that's the thing. It's like they'll come up with the craziest stuff. They're like, well, I didn't see, you said her mother's maiden name was blah, 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 but I didn't see the document. So I don't think you proved your case. And it's like, okay, meanwhile, we're talking about someone with a broken foot. What are you what's, it's just insanity. So do we work on how to find those people, who are detail oriented and try not to have them on the jury? Or do we really focus more on the simplicity of the timeline that we're giving them, and those people, I don't know, like, do you know what I mean? Like, that's a disconnect I have.
Well, and I think it comes back to, the thing we probably hear in every one of the EDGE classes that we take these days,
Mm-hmm.
how do you know if this works?
Mm-hmm. Yeah. Focus group.
Comes back to focus groups, right? Yeah. Focus group early and often, and keep doing it. Mm-hmm. One of the stories that I've heard that I think illustrates this point perfectly is, Don did a case of what I couldn't even tell you when it was, a case where a little girl was sliding down a slide at a public park, mm-hmm. and the tree branch fell on her, right? Mm-hmm. And, Don told that story in his opening statement, dealt with why it happened, how it happened, what was the system failure. But as I understand it, the way I've heard the story anyway, if you heard that opening statement, you never found out that the little girl's mom was sliding down the slide right behind her when this thing happened, right? I mean, what a huge, juicy fact that is, mm-hmm. And some of us hear that as lawyers. We're like, holy cow, well, that's the whole case. Mom mm-hmm. had to witness this. She was that close.
Yeah.
Right. But Don left it out because he focus grouped the opening statement. He focus grouped the facts of the case and the story and figured out that fact didn't have an impact on what he was trying to do in that particular trial. Mm-hmm. It made the story more complex. So he left it out. He simplified. And it all comes back to focus groups, Jenna. Every single time.
Yeah, that's for darn sure. Keep focus grouping everybody. That's a mantra. Focus group. But yeah.
But it's a good mantra to have because it works, mm-hmm. right? Mm-hmm. I mean, it allows us to do the things that we need to do and find out that they work. Mm-hmm. Find out what does work, what doesn't work, and it gives us confidence. It strips away that fear going into the trial that you would have had otherwise. If you're just going in and guessing as to what's going to work, you're going to be full of fear because you never know. You don't know what a jury's going to want to hear, what they're listening to, what's going to turn them off. And if you haven't focus grouped it, then, you just don't know. But if you have focus grouped it, what better shape are you in? You already know what people think about these things. You know what they think about your opening statement, about the story you're going to tell. And, it gives you confidence and it strips that fear away so that you can do the things that you have to do. You all of the system, all of the things rather than, getting scared and going into fight or flight or freeze mm-hmm. and that kind of thing. And it makes going to trial a whole lot more fun.
Yep. Yeah.
And so, but it's not just opening statements where, we need to exercise our simplicity muscles. It's literally every part of the case, and to a large extent, that is what the EDGE method is all about. It's creating simplicity with the goal of winning. And, every time I go to, read the book or I go to another class, we learn another system. And when you boil it all down, those systems that the EDGE has created, and Don has created with everybody else, is to create simplicity, to create something that a jury can understand and understand why a verdict should be given to our clients. Mm-hmm. And it starts, going back when we start developing our case. I learned about this somewhat recently in hit list training. I hadn't really known much about that, but in hit list training, at the risk of simplifying a 3-day course into a single sentence, it's taking a complex case and figuring out what the core set of things we need to prove are, and nothing else, right? It's those things, 2 or 3 things that we determined, we prove those things, we're good to go, right? And then everything we do at trial flows from there. If we've broken that down properly, you've got your hits, everything you do from that point forward, creates simplicity. In depositions, for example, when we have those hits, we know going into our depositions, we don't have to spend 8 hours, doing discovery during a deposition any longer. We know going in what has to be proven, and we do that, and then we're done. And it's scary walking out of a deposition of a defendant, in an hour and a half or 2 hours or whatever the case may be. But if you simplify it, you figured out what needs to be done, and you do those things, well, you've done your job. Think about those times where you're, sitting through a defense deposition of your client, and the lawyer says, let's talk a little bit about where you went to grade school. Right? And automatically, like, all right,
we're starting at the real beginning.
Right. Buckle in. We're here until, 5 o'clock tonight talking about a bunch of things that don't matter.
Meanwhile, when you're deposing their client, they immediately say, can we just get to the reason we're here now?
Right.
And I was like, okay. Can we talk about the case at hand, counsel? And I'm like, okay.
Right. But that complexity, and that spending time and going back 50 years, to the time when that person twisted their knees, that works for them. That works for black hats. The complexity, the vagueness of everything, raising innuendo, that's the kind of thing that works for them. And, they get paid by the hour. And so they can afford to spend all kinds of time, and, and they know it works. They know that by confusing the issues, it works. That's how they win cases. And so if we're going to beat that philosophy, we have to keep coming back to simplicity. No matter what they do, we turn that bus back around and drive it back to the land of simplicity, where a jury's going to actually understand what the heck is going on. Obviously, that applies to opening statements. Now, and for anybody who's taken the opening statements courses, I think this concept, this principle is probably made most apparent with that, right? I mean, there's a system for openings, and it's pretty well cut, what's the analogy I was looking for? It's cut out of stone, right? And we know what those pieces are. And when we follow that system, we take what, used to be probably a 30, 45-minute opening statement that the defense wants to give. We give this thing in 12 minutes. And the idea then is you've won your case. After those 12 minutes, you've won your case. And that's not guesswork. That, it's not something that Don just made up and taught everybody. It's something, it works. And works for good reason, because 12 minutes, it's tough to lose attention during 12 minutes. It's easy to lose attention after 30, 45 minutes.
Mm-hmm.
But if you've got them for 12 minutes and, you can give the jury the facts that you need to give them, the reason why you're giving them the facts, they can put it all in context, then it's like the story of the turtle hanging onto the oranges kite, right? Mm-hmm. You remember that. And they're not going to let that go. Mm-hmm. And they're going to remember that throughout the course of the trial, when you're presenting witnesses, and documents, and things like that. They're going to know, okay, this fits in there, this fits in there. It all proves it. Great. Wrap it up in a bow, come back with a 10-figure judgment. That's what we want.
Yes. Yeah. Well, what you're saying is really interesting, because it also helps us maintain our credibility. if you have 15 facts and, some of them are mostly true, but like the defense could kind of turn them against you or whatever, versus having 4 facts that are 100% true that you can prove all the time, you're going to have a greater chance of winning, because the jury is there looking for, you have the burden of proof, not only because that's your legal standard, but because in the court of popular opinion, nobody likes you. So the jury is not, we can talk about point of view and that sort of thing, whatever. But for the most part, the jury is not there to help your client. They're looking for holes in your story as to why this person, shouldn't get the money they're asking for. So, and that has happened to me for sure. Maybe it's happened to you, Sean, where you put too much in there and then they're like, yeah. And they're like, wait a minute, you said A in your opening statement. And then, but B, well, actually A minor came out during testimony. And I'm like, yeah, but it's still A. And they're like, no. And you get punished for that. So keeping it simple allows you to maintain that credibility, quote unquote, keep your story straight, which sounds terrible because we're not making up a story, but, keep it all very simple and maintain really what that jury is wanting from you, which is credibility and trust.
Right. It's hard to derail a story that's filled with 4 facts. Mm-hmm. It's easy to derail a story that's made up of 20 facts. Mm-hmm. Because it's just 20 more opportunities to punch a hole somewhere along the way. And if the jury thinks that I have to prove all 20 of those facts and number 19 gets a hole punched in it, we're done. And in jurors' mind, we're done. But if we have those 4 or 3 or 2 or whatever the case may be, by keeping it simple, you make the jurors confident in their ability to know that we're right and that the other guys are wrong, that everything the other guys are giving us is just superfluous. We don't need it. We already believe in the plaintiff's cause. Yeah, and then it becomes a situation of explaining and losing kind of a thing. If you're confident, you can prove your stuff pretty quickly. Then it looks like the other side is just like trying to throw stuff at the wall. And instead of us being the ones who are like, please believe us, please, Yeah, absolutely. Right. And we don't have, and when we go in, when we prepared for it, we don't have that fear any longer. We have the confidence in our 3 things or 4 things or whatever. And, it makes trial a heck of a lot more fun. You're not sitting in a hotel room at 2:00 in the morning worrying about what you didn't say or how you said it or what this other guy said about something. Those are the things that make trials stressful. And, and quite frankly, they're the things that make us lose. There's a good reason we get stressed about them because we know that's we're going down a bad path. And, and the same can be said, once you get done with your depositions, your opens, and getting into directs and crosses, it's all the same stuff. It's keeping it short and keeping it simple down to those core group of things, your hits, that we need to prove along the way. And, you do that and you finally get to your closing. And again, it's the same concept. You've got your pie chart. We're not reinventing the wheel every time we do it. You're just taking, again, those core concepts, putting them into the system and making it work and getting rid of all the other stuff that came out during the course of the trial that wasn't necessary or, all the stuff you gathered, during the course of your case preparation, and by keeping it simple, we're keeping the jurors' attention and we're honoring their time. And, and hopefully, winning as a result of that. Yeah. And it's really, when you break the edge down into the different courses we take, it's really, the courses lay out the system and we follow that system and we feed the system only those things that it really needs to work and nothing more, right? When you feed it more, that's when things go off the rails. And, and that's, we don't really ever talk about it, but like I said, simplicity is it's one of the pillars, I think, that holds the edge system up. So when we present a case with simplicity, we win. That's what it boils down to. I experienced this firsthand a number of years ago. I haven't been doing personal injury work for decades or anything like that. But when I started this journey, when I started first doing personal injury stuff and then, found the edge, I had an opportunity to do a medical malpractice case.
Ooh,
Yeah.
You jumped right in.
I jumped, yeah, like an idiot. I jumped right in. Up until that point in time, I knew three things about medical malpractice cases. They were too expensive, too hard, and plaintiffs never win. But I had this potential client come to me, this woman. She brought her medical records in, talked to me about her case. She had been fired from another lawyer in town who decided he didn't want it, that it wasn't worth pursuing. And she had had her gallbladder removed. And gallbladder is a relatively simple case, a simple surgery to do. You go in, you find the gallbladder, you cut the duct that holds the gallbladder and connects it to the biliary system, and you remove it. That's all it is. And this doctor cut the wrong thing, right? He cut the wrong duct along the way. I learned that from her, that doctor had cut the wrong thing. And I thought, well, that sounds like negligence. Let's go.
Yeah.
And, so I signed her up and I thought, wow, what a great thing to do. I've got my first med mal case. And then I wake up the next morning, I'm terrified, because suddenly I remembered all those things that I was taught about med mal being too expensive, too hard, never winning. And on top of that, knowing that I was going to suddenly be dealing with cross-examining doctors and defense lawyers who had been doing this for decades, and knew the medicine,
They know the medicine, man. Those defense lawyers know the medicine.
Yeah, they absolutely do, right? And it certainly put me at a disadvantage, having never done any of this, right? And so I started looking at this case and putting it together. And I had a very rudimentary understanding at that point in time, of what the edge system was. But one of the things that I did know is that, we got to keep it simple. And so that became the mantra, going into this case. So we made a simple rule, don't cut the wrong thing. And it was more wordy than that, but in retrospect, maybe it probably could have been: a doctor shall not cut the wrong thing, or a doctor must cut the right thing. And
especially on a simple case, simple procedure that they do all the time. I mean, it's not something, I always feel like med mal on a simple procedure can, focus group it, make sure what your people think, but can be, it's like, what? You do this all the time. How did you screw it up? Obviously did something wrong, that kind of thing,
Right. But when you ask that question to the doctor, it's a very complex sort of thing that we do. Even though we do it all the time, it's very complex. You wouldn't understand, all the variables that we have to deal with.
We're on the edge of medical malpractice every single second. So you know what, lawyer over there, it's a tough job over here.
Right. That's exactly right. And but when you break it down, I mean, doctors are like everybody else. They're like pilots. They're like, any other occupation that has a job to do. You break that job to do down its component parts, and it's really kind of simple. And so we learned, along the way, what the checklist was. And the checklist, we made that simple. You clear out the tissues around the ducts in the gallbladder. You lift the gallbladder up off the liver, and you make sure there are just two structures going into that gallbladder. And if you find those two structures going in, it's the right thing, and you cut those things. Right? You follow that checklist, that simple checklist, you can't screw it up. But doctors screw it up all the time because they don't follow the checklist.
Because their egos are so big.
Right. And, so every time during the course of that preparation, and I was fortunate to have another attorney who joined me, to help me not commit every single day. But every time things got complex, every time we learned something new, or, something about our client's health from 20 years prior, and, we brought it back to those simple things. You don't cut the wrong thing. And here's how you make sure you don't cut the wrong thing. And, we made, I think our presentation ended up being a little less than 2 days, and we won, And wow. So we came out of a medical malpractice case, my very first one, and we won the damn thing by keeping it simple. And, that's what I attribute the whole thing to. And then, of course, I got done. And I thought, well, this medical malpractice thing's easy.
Ooh, that's simple.
Bring on more. I had a lot of learning to do after that.
Yeah.
But we didn't win that because I had, Don Keenan trial skills or anything like that, or because I could quote you all the different organs inside of a person's abdomen and what tissue holds them together. It was just, we kept it simple. And, that was sort of my affirmation along my journey of, this stuff works. If you have that confidence to go down the road and ignore all the chatter and the noise and static around you, and keep doing what you're supposed to be doing, you're going to be successful. And we were, and the reality is it's hard work.
Yes.
Making it simple is hard. It's easy just to write everything out, and then regurgitate it in front of a jury, but it takes time to trim and to cull and refine the issues down to those core things, to those hits, that we need to prove. It's like anything else in the edge. It takes time. But if you take that time, you end up with a winning case. And so the question then becomes, Jenna, how do we know the simplifying is working? And you answered this question before, focus grouping over and over and over again. I remember hearing that early on, in sort of my edge journey. I'm like, oh, come on, man. How many focus groups can we possibly do? Right. But everyone that was saying that is right. The more you focus group it, the more you understand the issues in your case, what your case is about. You learn by teaching. It's one of the best ways to learn is to teach. And if you're teaching a focus group about your case and then, learning about everything you did wrong, it's the best way to refine your case down to its core facts. It's, making it simple, figuring out what works, and running. It's the same thing that Don Keenan did in the tree branch story, and when he learned that it wasn't important, he got rid of it. And it didn't affect the result of the case. And he knew that it wasn't going to affect the result of the case because the focus groups already told him it wasn't going to.
Absolutely.
It's a scary thing, and it requires faith. It requires confidence in the system that we're given and that we use. But if you follow that, and I would argue that it's absolutely necessary to follow that, the systems and the guidance you get. And if you do that, you're going to win. And, so you simplify the rules, simplify the language that you're going to use to tell those stories, simplify the story itself. And, if you're able to do that and you can spend the time doing all those things, you're going to have the keys to the castle when it comes to winning your case. And then it's just a matter of going out and doing it. And that becomes the easy work.
Yep. Absolutely. And for those of you that are watching or who are either with us live or who are watching this later, who are having a disconnect, right? Because we always talk about how the edge is a lot of work. It's about outworking the other side. It's about putting in time. This is a great reminder that work is not so that you put every single fact in front of a jury. It's really it's so that you have every single fact so that you have it, and then you can focus group it and distill it down. And most of the time that you're spending is figuring out what is the most effective fact or two or three, how best to present that most effectively. So I was just thinking about that as we're talking, Sean, that there might be folks out there who are like, wait, you're telling me that I have to do so much work. You do. And Dawn says a lot. This quote has been attributed to many, many, many people. I just Googled it, and it is not attributed to any one person, but a variation thereon. But the idea of if I had more time, I would make it simpler. Right. If I think Marcus Aurelius said, if I had more time, I would have written a shorter letter. I think Mark Twain said, if I had more time, I would have written a shorter story, whatever. It takes time. It takes a lot of work, but you're not working to create a complex case. You're working to create a simple, digestible, understandable case. And that, full disclosure, it's not something I've mastered. I'm still working on it, because I struggle with it.
Absolutely. And, because it's a hard thing to do. I don't think it's easy for anybody to do. Like I said, those roots of Paul's graph and all the other things, they run themselves deep into our psyches, as we're doing 3 or 4 years of law school. And it's tough to break free of that. I don't know of a single lawyer, who finds the concept of simplicity easy. It's hard. It takes a lot of work, it takes a lot of time, but we have to do it. If we're going to be successful in the courtroom, that's what it's all about.
Yep. Yeah, you really do. And the simplicity element of it too is also remember to be effective, right? And so you don't just distill it down so you have a certain number of facts. Like, I don't want to have more than 5 facts. I don't want to have more than 3 facts or hits or whatever we want to call them. Really, and we hear focus group over and over again, because it's not just about cutting it down to few facts, but it's about cutting it down to the most important ones. Just like in the slide case where Don left out the very emotional fact of the mother being right behind her daughter and witnessing this whole thing happening, not because he had to get rid of a fact, and so he chose to get rid of that one, but because he knew, as you already mentioned, that it wasn't going to make a difference. And so that's everything we do within the Edge. Whatever system of trial philosophy you follow or whatever, I always, for myself and what I tell others, is to think about why you're doing something. Why am I presenting this fact? Why am I using this witness? Why, and if it's just because of some kind of procedural thing, like, well, Sean told me to keep it to 7 facts, you don't want to fall into that trap, because what Sean is really telling you is you want to make your case the most effective by presenting the facts that are going to win your case and not wasting everybody's time with the rest of it, right?
Yeah, absolutely. Everything has to be done with a purpose, and we get a lot, we get a lot of rules and methods and systems and things like that, as to, using checklists in the opening statement and things like that. It's important. It's always important to understand why you're doing that, because if you don't, you're not going to do it right. But that's the great thing about the plaintiff's lawyer community and the Edge community is everyone's always willing to talk about those things, and talk about why it's important, how it's important, so that, so that you can implement it appropriately. Don't ever do something just because someone tells you. Know why you're doing it for every single part of that case.
Mm-hmm. Yeah. And even Angie and I do this with each other all the time, where, one of us will say, well, this is what I'm going to present and blah, blah, blah. And the other person will say, okay, why? Oh, well, because I have to meet this burden or that burden. It's like, okay, well, but is it something we really need? Is it going to be effective? Are people going to appreciate that? And could we cut a day off of trial by, having another witness answer one additional question instead of putting on somebody else for an hour or two, Right. And so there's a lot of elements to simplicity. Simplicity is very complex, Sean. Simplicity is very complex.
It is, Jenna. It's a very complex subject. We've talked for a whole hour about simplicity, for crying out loud.
I know. Look at us being true lawyers and making something simple complex. We just can't help ourselves.
That's what we do best.
I know. Also, we like to hear ourselves talk. So this has been fun. Awesome. Well, Sean, do you have anything else you want to share with us this afternoon, or are we wrapped up?
I don't think so. I think I'm all talked out on simplicity.
Awesome. Well, thank you very, very much for being here with us today, Sean. And thank you to all of you who joined us live for this week's episode of Fridays with Keenan's Cutting Edge. As always, if you liked the episode today, please click that thumbs up button. As I've mentioned in the past, it's not just an exercise. It actually helps us reach a wider audience. So if you are a fan of more simple trials, then click the thumbs up guy. More people will learn about it. Also, don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have Matt Powell with us. He's going to be talking to us about the Keenan case presentation system. Now, this has been circling, and there have been rumors and rumors of rumors and all kinds of mystery around this Keenan case presentation system. I even got to kind of dabble with it a little bit, but I think we've all been waiting a long time for this program to go live. So I look forward to hearing where we are in the process and what tools are available to the Edge community right now from Matt, along with all of you. So have a wonderful weekend, and I'll see you next time.